All right. Good morning, everybody. It is September 21st. It is 10 a.m. My name is John Belamowitz, Chair of the Texas State Board of Examiners of Psychologists, and I'm calling this meeting to order. Ms. Moore, will you call the roll for us?
Sure, Mr. Adler,
Here.
Dr. Becker.
Present.
Okay, we have Mr. Bridges,
Here.
Dr. Calhoun, Dr. Cartwright,
Here.
Dr. Lambden, Dr. Singh, and Mr. Zagaris.
Here.
Okay, we do have a quorum present.
Very good. Thank you very much. We'll begin with public comments, limited to 3 minutes per individual, unless for some reason I want to let you go longer. But please be aware that we can't take any action or discuss any action not on the agenda today. And if I know we had a petition for rulemaking, if that person is here and wants to make comment closer to that point in the meeting, I would be happy to take that comment then later in the meeting, if so desired. Otherwise, now would be the time. So, Ms. Moore, I'll turn it over to you to run public comment.
Sure. So any attendees virtually here, just raise your hand and we'll call on you in that order. We do not have any hands raised and there are no callers viewing by phone.
Okay, thank you very much. Moving on, moving over to the chair's report. Usually I don't have a whole lot to cover here, but fellow board members, I direct you to the update in your materials from last night. I wrote a letter to all of you as my honorable colleagues here on the board. There have been some discussions that I've had. I'm not going to out the other states regarding EPPP2. And I think it's pretty clear with a lot of the feedback that we've received and conversations that I've had. I'm still looking for proponents or people who are going to explain why this is needed. And when it comes to stakeholders within the state, I've heard not a lot of support for it. And so there's a lot of different reasons that people have questions about this. Many different angles from different kind of places. What I have not seen over the past year since ASPPB announced this is I've heard a lot of private chatter, but not a whole lot of public statement on it. And so for the record, I'm on the record today is that I see no reason to advance this at this time. And I recognize that that's alarming probably to some people because the alternative, as ASPPB has put it, is that we don't have a test. At this moment, I wholesale reject that idea that there is no other option. I don't know what that solution is. And so I would ask you guys, I'm asking you guys, and not just not my fellow board members, but stakeholders here in Texas, put on your thinking caps, and I want to explore alternatives. What I did not want to do, what I would like to see, I don't know if there's what the appetite of the board is. What I did not want to do is to circulate a letter outside of a public meeting. If there is any appetite from the board to make a statement and to join me in the questions, and it doesn't need to be anywhere as strongly worded as my letter to you guys. If there is an appetite from the board to say time out, hold the phone, we want to have some input on this, I would like to do that, but I would leave it to the board to work its will. If you guys agree with that, great. And if not, I'm telling you guys where I am on it. So with that, I don't want to have too long of a discussion on this, but if everybody has any comments, anybody should feel free to speak here. So Herman, yes, sir.
So you're asking us to kind of talk about options as if we don't adopt the EPPP2 kind of, what I gathered from your letter is that is our ability to administer the EPPP Part 1 in danger if we decide not to do the EPPP2?
That's what ASP, that is the unwavering stance that ASPPB took a year ago at their annual meeting and has thus far not yielded.
So we need EPPP, obviously. but I hear your comments, and I don't disagree with them. It just worries me a little bit about if they pull the plug on our ability to administer the basic exam that we've been administering for some time now. I'm not really sure. So that's really my main concern.
That's what they've, just to be clear, that's what they've stated, is that if we do not move to adopt EPPP2, the test EPPP as it exists, we will not have access to. My concern is that other states have started to explore the idea of creating their own test. And while I'm not ready to direct our staff to do the same thing, if there are enough states that are having the same questions that we are, and we didn't get a vote on this at ASPPB last year, it was announced by their board, and I got the email while it was announced to the rest of us in the room at the time. I think there's enough of us that have questions. I just haven't seen anybody go on record outwardly yet about it, and that was my intent here. Dr. Lambden, I think you had your hand up next. Dr. Lambden, you're on mute.
Thank you.
There we go. We want to hear
Can you
you.
hear me?
Yes, ma'am.
Okay. So I went ahead and did a little bit of, number one, I'd like to say that I don't really hold a position either way. I think the most important part for me is for us to kind of take a time out and explore a little bit more judiciously what our options are and consequences, when any of those options are adopted. I will tell you that as of right now, to the best of my ability, according to ASP PB's website, there are just a few provinces in Canada, but also there's, I think, Nevada and I believe Georgia are the only states that have signed on and have and are now implementing this. To my understanding, I do know that since it was incentivized in the very beginning, Arizona also adopted the part 2, but since I want to say February of this year, they have opted out, and they have decided, and it doesn't say publicly, I couldn't find why. So I think just a conversation with somebody on the board over in Arizona might be worthwhile to us to assist us to gain a clearer understanding as to why they decided to take that route and rescind their participation at this time in the EPPP. I know that several states share your concerns, John, including California, who put together a task force to look into this, and had a conversation with the staff at ASPPB about the validity and why there was a reason, a rationale. And I will say that they were, I think at this point they had concerns as well. They developed an option that they would look into, and I can't remember clearly what that option was, but it did involve part of it was, I believe, an option to adopt the EPPP, but I may be mistaken on that. So again, I say that cautiously. I will say that they were concerned, and rightly so, about the portability of a California license with the rest of the states if they develop their own instrument as a competitor. And I think we have to really think about, if we do this, then I think it has to be some sort of consortium, some sort of a joint effort or co-effort with other jurisdictions.
I completely agree. And Dr. Lambden, I'm glad you spoke up because you're going to the meeting. I hope that you will carry our concerns there, and to any relationships or contacts you can make with other states to get their 2 cents. I hope you'll report back to us.
I will.
Good deal. Mr. Zaguris, you had your hand up.
Yes, I agree with Mr. Adler to a degree that we can't just, jerk the stool from under us. We've been doing this. We have to have something to take the place. However, if we're going to go along with your lead, sir, and I am on your side on this, let me just advise that there's companies out there, one in particular in New York City, and they do test prep for people that are going to take different kinds of exams, social work exams, LPAs, LPCs. And so you go, you order, you pay $1,000, and you get these 6 or 8 boxes in the mail. And you go through all this training and all that. At the very end are practice tests. They teach you the stuff, and they throw you the tests that have been developed over the last, I don't know how many years. Each test is weighted differently and all that. And they have some statistical thing that this is the test you might get. Well, they have like 50 tests in the back that give you practice on taking tests. The people that make EPPP aren't the only people that make tests. I mean, there's examples everywhere, and I think there's other people that can make tests. Psychcorp could probably make tests.
Thank you, Mr. Zagaris. Dr. Becker.
I was just going to say, I'm going to throw my hat in the same place that Dr. Lambden did, which is I think that there are a number of states, and I think that next week when you're at the ASPPB meeting, it's a good place to talk to those other jurisdictions. And that was what I found when I was at the last ASPPB meeting, and I appreciate that you're going because I couldn't. The representative, both from APA and from a lot of the other jurisdictions, just informally, because I found it very interesting that APA in a 3-day meeting had exactly 1/4 of a session about EPPP, and that's all that the jurisdictions wanted to talk about. And we were very restricted from talking about it. Probably not the only thing we wanted to talk about, but it was kind of the only thing that the jurisdictions were talking about on the sides with each other. But it wasn't part of the content of the meeting. And it felt very purposeful. And so the jurisdictions were talking about it a lot. You know, the representatives were on the background, and there was a lot of malcontent about it. So I do think that there is a big want to talk about what are our alternatives, or at least what is it that we can talk about kind of as our options. Because I think this sort of adapt or don't do anything at all feels very like this is being done to us as opposed to with us. And that feeling sort of seemed to come from APA as well. And so I don't know that this is as doom and gloom. It's just that everybody's sort of sitting back and waiting for everybody else to kind of make a move. And I don't know that that is without a position. So I agree with you.
Thank you, Dr. Becker.
I have a question.
Yeah, Dr. Singh, then Dr. Cartwright. Go ahead, Dr. Singh.
Could we, since John, Mr. John has looked into it quite much and to take such a position, could we look at some of the pros and cons of taking, going with PPP2, and also just like Mr. Adjani said, that we have other companies that can make exams. You know, it's not like even we all can make exams. And what is if we refuse to cooperate with them, what is the problem with that, and how much time we have to think about it before we give them the answer? Several questions.
Thank you, Dr. Singh. Yeah, I think it's 2026 is the deadline of what they've put on this. So we've got a little bit of time to figure this out. I want to be very clear to the questions here. I don't want to knock the stool out from under this thing at all. The difference, though, is that it's ASPPB who drew a line in the sand and has been unwavering on this. I would love to work with them on that. They just have not, at any point through this over the past year, shown any willingness to move on this. So that's I hope that speaks to some of your questions, Dr. Singh. And Dr. Cartwright was next.
Yeah, I would just have questions also about like what the implications would be for SIPAC and for the port, like Dr. Lambda mentioned, the portability between states. If one state adopts it, one state doesn't. Those are just things that like I'm immediately thinking, you know, pros and cons in both directions, but just things that like definitely stick out in terms of more clarity and how it would work. And just those are the things that kind of on my radar.
I
as
share
well.
that concern. Dr. Lambden? You're on mute, Dr. Lambden.
Yes.
We want to hear you so desperately.
So anyway, my thought, sorry, technology again. So my thought here is just a couple of questions. Really, I think it's quite apparent that many jurisdictions have concerns, and otherwise we would see very clearly people adopting this for the rollout of 2026, January 1st. And eventually, really, as I read and as I understand, please feel free to correct me if I'm in error, that it will be combined. The EPPP Part 1 knowledge with the EPPP Part 2 skills will be rolled out as one test. That is my understanding. And so there will no longer be, and as they stated unequivocally, there will not be an option to take one or the other in the future. To somebody else, and I forget who that was, saying that they have, you know, drawn a line in the sand very clearly. I think it's incumbent upon us to reach out to other states. And I think that with added numbers of individuals and jurisdictions having reticence about the, you know, moving forward on this path, I think it makes sense for us to approach ASPPB and speak to them about any sort of, you know, compromise, given all of our concerns. And I think it was Dr. Becker that maybe stated that we all feel that this is being done to us rather than with us. I think that, I just think it's an approach, an option that we can't neglect at this point before moving forward in any other direction.
I think, and also what I'm asking for, Dr. Lambden, you're I think exactly right. And I think what I'm asking for here is that if all 9 of us have questions, what I'm suggesting is that we write a letter saying, we're Texas, we have some questions about this, and all 9 of us do. It doesn't need to be strongly worded. It doesn't need to be fire and brimstone. That's all that, what I've not seen from any other state is I've heard lots of questions, but no one's been willing to just actually put it in writing and say, we have questions. And I think that given this conversation, it feels like that's something we could consider. And
Well,
go ahead.
Sorry. Well, I have to say, as I mentioned before, California did have questions early on, and that task force reached out to ASPPB about, the validity of the items, the cost, the portability. I mean, what are the options if, any jurisdiction does not go forward with it? And it's my understanding that there wasn't really, other than reiterating all of their justifications and their rationale for moving forward in this manner, I don't think that there were any real clear, given that California still has not adopted it. It's my understanding that, that they have done that, and that hasn't I'm not saying necessarily that we should not do that ourselves. What I am saying is kind of bringing awareness to the table that a state has done that.
Yep. Mr. Spinks.
I think it's probably important to point out I don't have the solution, but it's a practical concept, and that is, this is not an either or problem. I think you could say we will also adopt an alternate test, because Dr. Cartwright brought up the SIPAC issue. If you do away with EPPP, you lose access to SIPAC. I mean, the people that have passed and are already licensed, yes, they would be able to participate in SIPAC and if they could get the certifications needed from ASPPB. But what I'm trying to say is, I don't want the public or the board members to have the mindset that, well, we must choose another exam and forego the EPPP altogether, or vice versa. We can only accept the EPPP and nothing else. I don't think that's true. I think you can accept an alternative. The problem is there is no alternative right now. And from a financial standpoint, I'll just be candid. I don't want to be responsible for creating, you're talking about a significant investment not only in setting it up, but in maintaining it. And while candidly, this is probably the perfect crowd to do it. I mean, this is the right profession to set up a new test. You guys are all, you're the experts in that, in establishing testing. That's a Herculean task. And that really is where I think cooperation with our other states is going to be critical, and seeing where they stand on it. But anyway, I'm getting too far afield. I just wanted to make sure that kind of manage expectations, make sure everybody wasn't thinking this is an either or. I don't think it is. I think it's, well, we will continue to accept the EPPP, but you got to take parts 1 and 2, since that's what ASPPB is going to mandate. But we've also got the other option of adopting another exam out there. So just something to think about.
To Dr. Becker's point, thank you, Mr. Spinks. To Dr. Becker's point, and to echo, I think some of Dr. Lambden's concerns, talking about partnering and conversing with other states, usually and historically, ASPPB has been the vehicle for which we do that. And Dr. Becker pointed out, I think rightfully so, EPPP2 was put in the back corner of discussion. It wasn't had, outwardly. And then again, if we were going to debate these things, I would think usually the membership would debate it. And I just want to remind everybody, the membership never voted on this of ASPPB. The states never actually got a say in how this was going to happen. And this is ASPPB is the association of other boards like us. And my frustration is that the board seems to not be listening to its membership, because I've never in my tenure on the board seen this much chatter nationally and have it being squashed by the organization nationally like this issue has. So practically speaking, I don't know how else to talk to them other than through a letter.
Well, that's probably a good way to start, right? And I just want to say, John, I appreciate taking this stand to write the letter and bring out your comments and thoughts so concisely and clearly, because it's been what a lot of us been thinking. But that helps to have our leadership give such a clear explanation of his own views. So I appreciate that.
Thank you. I'm going to put it on the agenda for the next meeting to see if there's something that can be developed that simply says we have questions. And I hope it's something that if we can say that in the most polite terms, I would love it if it's written in such a way that all 9 of us could sign it.
I also think it'll be helpful to hear what Dr. Lambden comes back from the next meeting with.
I agree.
Because the tide may change from the midterm meeting to now, particularly if more of the states are in a similar or the same place as we are. So I think it'll be interesting to hear in the last 6 months after that hard line was taken and they touted out the statistics and some of the information that they put out at the mid-year meeting, to hear where folks are now. So I'll be interested to hear what you bring back, Dr. Lambden.
Agreed. Thank you, Dr. Becker. Mr. Zagouris?
I'm not one to procrastinate, but we do have 2 years from that 26 deadline. And just because somebody puts a deadline, John, doesn't, I had a lot of bullies while I was growing up with my weird name, and they always were going to punch me, but they only punched me like once or twice, right? And so bullies are going to do bully stuff. And so then, and in 26, between now and then, hopefully we're going to come up with something. We're all discussing it. Looks like we're going to sign some letter, but just because somebody tells you they're going to kick you out, now you can't play with my toys, doesn't mean that it'll happen. That they may get word of all of this concern and discussion and all this stuff. They might be ignoring it right now, but in 2 years they might not be.
Yeah, I agree with you. I think the thing too, when you think about rulemaking and that process, for something as big as this, and the fact that it's not just us that this would have to get, adopting this would have to get, obviously we'd have to decide to do it. Secondly, it'd have to get past BHEC. Plus there are plenty of other regulatory hurdles within the executive branch of our, we are a part of the executive branch of our government, and here in Texas, there's other hurdles that we've got to get through that I don't know how this is going to pass muster as it sits. And so that's part of this, is kind of sounding the alarm to say, I don't know how this is supposed to move forward. So with that, I appreciate y'all's discussion on this and all of y'all's expertise. I certainly don't have it. I just have questions. So I appreciate, yes, Dr. Cartwright.
Well, I was just going to say, John, I like your idea, though. I don't think there's anything wrong with writing a cordial letter asking for more clarification. I think it's a great idea. I mean, we'll see what they come back with, but I guarantee you that other states want to do the same thing. So maybe it'll be something where they can address it. But I think Dr. Lambden, when she goes to the meeting, will be able to provide some good insight and about the temperature and everything else. But I do like the idea, and I'd be more than glad to sign. So
I appreciate that, Dr. Cartwright. I think the biggest thing, because I'm not going to out. I've had some off-record conversations, and I'm going to honor those commitments to not out them. Some of these other states have pointed me to their discussions and like 3 hours of discussion on it, and like I had a hard time finding it, and I'm looking for it. And that's where I feel like a letter to where it's just concise, where our position as a board, you don't have to go look through our minutes or our videos. These videos are our minutes. That you don't have to go through hours of this stuff to figure out what the heck we think. Dr. Lambden.
Yes, I just wanted to say it makes sense, at least for me, sequentially. It makes sense for the conference to take place, kind of see what comes out of that, and then write the letter based on, what we learn. I don't know if people are in agreement, but to me, it seems like jumping the gun a little bit to write a letter, and it's next week. So, I think we'd be have to hurry and put something together in a rushed way. And I just don't think that makes sense.
I completely agree. Thank you, Dr. Lambden.
You're welcome.
Unless there's other discussion on that, I'm going to go ahead and turn it over. Another discussion, I'm going to turn it over to Ms. Moore for the board administrator's report.
Okay. This will be real brief. For SciPac, in your packet there, it just shows that we are in compliance with the second quarter reporting requirements through SciPac. So there's nothing, new going on there. For ASPPB, just a reminder, we do have a conference coming up next week. Dr. Lambden and myself will be attending, just to go over some of the topics that will be discussed that's on their docket. They're calling it the nuts and bolts of regulation, practical skills and strategies. We're going to be discussing disciplinary issues, doing a mock hearing, looking at licensure applications to make sure that they're fair and not biased applications. And then any legislative issues that we're being faced by ASPPB jurisdictions, licensure at the master's level, and then be some discussion on continuing education versus like continuing competence type models. So that's what's on the docket. So, as far as EPPP, I don't see that standing out unless they touch it on the legislative piece. So we definitely would need to, kind of do sidebar discussions to see what other states are viewing as far as the EPPP Part 2 part. And that's all I have for you guys.
Thank you very much, Ms. Moore.
You're welcome.
Moving on to the enforcement division. I think we have some dismissals to just look at. I don't believe we have any action on this. I'll turn that over to Mr. John Bridges.
I can get myself unmuted here. Yes, does anyone have any questions on the list?
I do not.
Can I ask a really quick question? It's a silly statistical question. On the first page, there's a pie chart of complaints closed. It's a complaints resolved pie chart. I don't know who makes that. Do you know which one I'm talking about, John?
I see it and I did not make it.
Okay.
Alfonso makes it.
Okay,
The enforcement manager.
okay. Does anybody have any idea if those are the percentages of the total complaints or the percentages of each board? Because I was looking at it and was unable to understand the pie chart. Because
these
there,
are-
sorry, there's a helicopter landing outside my window as I'm trying to explain this, and it's really hard for me to hear or hear any of you.
Okay.
So I'm trying
Yeah.
to understand, like, so if I'm looking at these two pie charts side by side, the bulk of it, we'll just talk about the blue one. The bulk of it is, let's talk about us, okay? The Texas State Psychology Board. On the left, we've got 22% of our complaints were received and 15% of our complaints were closed. So is that 15% of the 22%, or is it 15% of the open complaints were resolved?
Let me do some quick math here.
Right?
I see your question, Dr. Becker. It's a good one. I have a feeling looking at the it's a percentage of like the 627 complaints closed. I just have a
Okay.
feeling it's just showing as a
It's
ratio.
of the overall, right?
Yeah, of
Yeah,
overall.
and it's in the last year in that time frame. So those are complaints
Okay.
maybe filed
Okay, I was just trying
before.
to understand math
the
because
fiscal
math is
year.
not my strong suit, but putting these
Yeah.
two things side by side really confused me. I'm sorry, math is so not my forte, but putting these two charts next to each other just rocked my world a little bit, and I spent too long looking at them. I confused myself.
I see your question. Because
People that live and work around helipads shouldn't have that kind of problem, Dr. Becker.
I'm sorry.
The other thing that would be interesting to know, and sure it's in the data's in here, is in terms of how many complaints do we have and how many of them were closed as a ratio between those two, which I don't know if we have that data presented here. Do we? Or do we know?
I'm not sure what y'all are asking, to be honest with you.
Like as a ratio of if I've gotten 100 complaints and I've resolved 80 of them, I've resolved 80% of my complaints.
Right.
That's not what this is showing here.
Putting these two things side by side, Daryl, basically, it makes you think that they are related to one another and they're not. That's all. That was sort of the question I was getting at. They're completely unrelated. And that's all it is. So we can move on.
If Alfonso's around,
It was a timely digression into my warped brain.
And
Let's just move on.
It's also, this is geared really more towards the council, which is tasked with this. And so the council looks at it from all of these are the council's complaints.
Yeah.
And so it's geared more towards them as an audience and not really the individual board. So I think I see what you're saying now. It's not designed with you all as the intended audience.
And so would you say that the large percentage going to the counselors is because of they have the most licensees of any board? Is that it? Okay.
By far and away.
Yeah.
I mean,
Got it. Okay.
Yeah, this makes more sense knowing that BHEC is the audience of this. So, okay, if there's no further questions, we can move on. That concludes everything from you, Mr. John Bridges, correct?
I believe so.
All right, we don't have anything on committee reports on applications or compliance. Moving on to rulemaking, we have a petition for rulemaking. Daryl, Patrick, I think there's this is dated for tomorrow. Is this a draft denial? Is that correct?
Yeah, the letter's dated, excuse me, for today, and it's a proposed denial if the board chooses to deny it, but it's essentially a amendment to the psychologist licensing rule, creating a carve out for internships that don't have two full-time psychologists or two full-time interns that participate in the internship, and those would be for applicants that are licensed as a LPA or an LSSP when they're completing that internship in their doctoral program. Part of what the denial letter talks about is that there's already you guys already adopted a rule that allows for remediation of these sorts of deficiencies. So if somebody comes in and they have an internship where they don't have 2 interns, or they weren't supervised by 2 psychologists, they could ask for a remediation plan and the board could create that. This just would put in a rule and automatic exemption for it. So I don't know that we need to keep creating more and more carve outs, because we already have so many. And so that's what the letter essentially says is, you know, there's already a solution to the problem you've raised in your petition. And so, you know, we don't feel like rulemaking is necessary to address this any further than what the rule already has. So
Good deal. Dr. Lambden.
Yes, I just wanted to also point out, if I'm not mistaken, also, couldn't this also be resolved alternatively by, you know, some sort of telesupervision? You know, with, if they don't have 2 supervisors on site, couldn't they also reach out to secure a secondary supervisor somewhere else through what we allowed with telesupervision being allowed?
I'm curious. That's a good question. I'm curious from the professionals, practically speaking, how would that work?
I'm not sure. Maybe Dr. Becker could help us, because I think you kind of work in that realm.
I don't understand. The 2 full-time supervisors or the 2 full-time supervisees?
Well, my proposed solution, or kind of, you know, kind of bringing into the arena the possibility of a solution here, not only kind of with some sort of an exemption, but also a while ago, and it started with Corona, we also said that, you know, obtaining supervision through, you know, supervision would be something that the applicant would have access to, not necessarily physically within the same setting, but could reach out and obtain a secondary supervisor to secure a secondary. And so I think that, you know, somebody was bringing up the question of, practically speaking, how would that work out? And I think maybe you could elucidate better on that.
So the issue would be then, would telesupervision qualify as having the 2 psychologists on hand, or even the trainees? They could do tele-trainee, whatever. And so that would take the place of the requirement of having 2 psychologists at the facility where the training is going on.
Mr. Hyde, I think, did you have something to add?
Yeah, I think so. What the rule currently requires is, as it's stated in the rule, depending on what type of internship it is, it says the internship agency must have 2 or more full-time licensed psychologists on staff as primary supervisors. And then the other part, if it's the LSSP, it says the internship agency must have available at least 2 full-time equivalent psychologists as primary supervisors, at least one of whom is employed full-time at the agency and is a school psychologist. It's hard to speculate and kind of think about all the different things that could work in that scenario. Is it possible that some sort of form of tele supervision would be allowed? I mean, under the 465.2 supervision rule, it does allow for supervision via, you know, technological means, so I think it's possible, but they would need to be, you know, full-time employed there. And I don't know if it would be, if they just contracted for some person out there that's not really that associated with that internship agency. They're not really full-time employees or part of that internship site. So possibly, I guess, is the best answer. It'd be hard to meet the internship requirement, but I guess unless one of the full-time interns is a full-time virtual, I haven't personally seen an application that has that, but not to say that it maybe isn't a possibility. I haven't seen it. So
I think the bottom line is that there are multiple pathways by which to achieve this that we've created through remediation. And so I don't know that we necessarily need another rule that puts something on the books that has an automatic exemption when you've created a pathway for looking at things as they come up, so that every permutation doesn't need its own rule, right? So this case by case basis is what we built into the rules. So I don't know that we need more that gives a kind of automatic rule to any particular situation. That was kind of what we were looking for in adding that flexibility.
That's exactly how I see it as well. I mean, the whole intention of the rule was for us to be able to have flexibility and on a case-by-case basis. So I'm completely with you, Dr. Becker.
Y'all might, Dr. Cartwright, Dr. Becker, y'all might be surprised. I completely agree with everything y'all both just said. Here's the question I have though, and I hope somebody or anyone can jump on this. Obviously, this has been an issue before. This is why we had multiple board meetings dealing with remediation around this issue of 1 versus 2 supervisors. The fact that it's coming up again, and we've got another example here anecdotally of this is apparently bottlenecking people into the profession. Does the fact that we have an exemption, or not an exemption, a remediation, the ability to make a remediation, does that not have a chilling effect on somebody embarking on having a 1 supervisor relationship and then petitioning the board? Hopefully, I hope that they will give me this remediation plan versus having something that's a clear pathway when they embark on the journey. Dr. Lambden.
I would say.
John, I think this is the best we can do. I think that it is absolutely essential to have the 2, and we've discussed this ad nauseum. I think that it's very clear and I think we're all in agreement from the professionals in the profession that have gone through formation, that it's absolutely essential to have that secondary supervisor on site. And I think this is the best we can do while allowing still the flexibility for each individual applicant to have some sort of an alternative that can be generated and developed with approval from the board, without just giving just a blanket sort of an exemption. I'm open to anybody else that has any sort of differing opinion.
No, I agree with you, Dr. Landon, also, because I think we need to trust ourselves in that if we see a legitimate case where, it would allow for remediation in such a case, then we should trust ourselves to recognize those that really, fulfill the spirit of why we made that rule change, and the potential detriment of making a blanket kind of statement where it could do a little more harm than good. But the belief that we can trust ourselves whenever we're faced with this kind of decision, I understand it may be anxiety provoking for those applicants who have to ask for a remediation and whether or not we'll grant it or not. But I think it's a very reasonable approach that we've made. So I'm in agreement.
And I think it comes down to the balance between public safety and education. And so I think we can talk about kind of what are the things that we as Texans and as regulators can promote towards putting out more supervisors and opportunities for supervisors to exist. And what Dr. Lambden was talking about, we've made there opportunities for more telepsychology to be used to promote the opportunity for secondary supervisors to exist. We've had opportunities for educational programs to create pathways for supervisors. We've talked about potentially having supervisors who are willing to connect to rural institutions of education and people who are willing to connect with rural supervisors, have perhaps, lesser licensing fees or things that we have regulatory control over, be connected in some way towards the promotion of more supervisors out in rural areas. But when you reduce that second supervisor in the training years, you are reducing the access to things like due process, to having supervisory capacity and the opportunity to be able to learn therapeutic process. There's a power differential in learning therapeutic process and psychology that doesn't exist in other professions. That's why you have 2 supervisors. It's not to make things harder for interns to get out of their degree. It's to allow them the growth to be able to speak up and learn things, and not have that power differential in play. So it's not there to make things harder for them.
Appreciate everybody's discussion here. Is there further discussion or any motions?
A motion to deny the petition for the rulemaking change.
And Patrick, do you need a motion on the letter?
Yeah, if you approve the letter, I'll send the letter today.
Would you, okay, and so with, you've seen the letter, does, Mr. Adler, does your motion include approving that letter?
Yes, it does.
Okay, you've heard the motion.
I second.
Been seconded. Further discussion? Hearing no further discussion, all those in favor of denial say aye.
Aye.
Opposed say no. The ayes have it. Thank you very much to the board. Okay, it was been brought to my attention by Ms. Moore. Thank you, Ms. Moore, for keeping me on track here. I did, coming back to ISD panels, I failed to make assignments or accept volunteers for September through November of 24 for the ISC list. So need a professional and a public. I've got a few months there ahead of that. I've not volunteered, so I'll volunteer myself. Any other volunteers? Dr. Lane?
I will volunteer myself.
I had sent an email to Ms. Moore that to put my name on the one that you had question marks on.
Perfect.
Yeah.
If you need an LPA, if I'm still on the board, which, you know, my term end date is coming up next month. I've been in contact with the board, the governor's office about extending it, but if I'm still on there, put me down.
Good deal.
We need an LP or an LPA, a public member, and an LSSP. So that's kind of the combination you need.
Hang
I'm
on.
doing it either.
So
General
Doug,
Put my name down. You can put my name down anywhere. But I have the same situation as Mr. Adler. My term is up, and I'm hoping I'll be reappointed, but I don't know what they're going to do.
sorry, Daryl, help me out again. Who do we need?
You need an LP or an LPA. Those are kind of interchangeable.
Okay.
And then you need a public member and then an LSSP.
You're talking about for ISCs?
Yes, for ISC.
Is this new?
No.
No, it's not new. It's just that's how we make sure.
Each license representative.
Yeah, that each license is
I'm
the area of.
as well, so you can put me on.
Okay, so Dr. Cartwright covers us on the LSSP
And LP
psychologist.
and LP.
And yeah.
Yeah, or Andoni covers both on LPA and LSSP.
Okay.
So
and
each of them cover 2 slots.
Dr. Singh,
Yes.
myself, and then Mark covers us as well. Okay.
There's no
Yes, sir.
LPA. Oh, it could be psychologist or LPA.
Okay. So we'll put without objection, Dr. Cartwright, Dr. Singh, and myself for September, November of 2024. Hearing none. Thank you very much, guys. Okay.
Quick question for you, John.
Sure.
I was actually more for Patrick. Do we have any SciPact updates, or was there anything else that I know that there were some like rules, things like that were going on over there, but I didn't know if you had any updates on it.
Yeah, their big meeting is coming up here or their annual meeting is coming up here in November. I can get you the exact date. I know it's on November 16th and the 17th are the main meetings. On the 16th, there's actually going to be a public hearing about some of the rule changes that they've proposed. But the big annual meeting is coming up then. I don't know if you want to, if there's any like specific questions about it, but right now they're up to about 40 jurisdictions, I think, 40 enacted, 39 effective. So it's definitely growing, but there's not any other big changes other than, I mean, they'll have some of those rules that are coming up. I think the rules generally talk about it's a clarification on the commission has never been of the belief that the authority that SIPEC issues is something that could be delegated. And so there are rules basically stating that the temporary authority to practice in person, or the APIT, the authority to practice interjurisdictional telepsychology, is not an authority that once you get, you can then delegate to supervisees or subordinates or whomever. And I think I haven't seen anything. I just know that they're scheduling a public hearing for it, because I think people have questions, concerns, whatever. So
Thank you.
Thank you, Mr. Hyde. Okay, that wraps up rules. Moving on to item number 8, discussion and consideration request to modify a licensing contract. So Dr. Becker, myself, and Mr. Hyde met recently on this with the licensee and the licensee's attorney. I'd like to yield, at least give Dr. Becker the chance if she wants to go first, or if she has anything she'd like to share on this before I keep going. Shaking your head.
Just real quick on this one, I'm going to go ahead and recuse again because I was recused on the last one. So just if there's any vote or anything like that.
Thank you, Dr. Cartwright. Dr. Becker, you want me to go on this? Okay. So Dr. Becker and I, Patrick, go ahead. I'll let you go first.
Oh, I was just going to say, I think Mr. Montez is in the audience. So whenever you're done, I told him we would give him a few minutes just to sort of state his case. And in the materials is for convenience purposes is the draft changes that they're requesting now. And this isn't a staff recommendation. This is the licensee's request. And so the draft is put in there just for convenience purposes. So you can see the language of the current licensing contract, what they would like to be struck through, and then what they would like to be added. But sorry to cut you off.
No, good. No, thank you. So Dr. Becker, myself, and Mr. Hyde met with the licensee and the licensee's attorney in Dallas. We had I think a good discussion. But yeah, I'll turn it over to them to let them speak at this point. Mr. Montez, are you on?
Yes, I'm on, and I know Dr. Mancuso is on there too. I'm not sure if you're able to see him, Patrick. He may have to raise his hand, right?
There he is.
There we go. We'll give you guys usually in public comment we'll do like 3-ish minutes.
Sure.
I'm happy to give you guys each that amount of time. So
okay.
I'm here.
Okay, thank you. Thank you, board, for meeting with Dr. Mancuso and I. As you may be aware, the request here is to change some language in the current licensing contract that Dr. Mancuso is currently under right now. When I came on board, I did not represent Dr. Mancuso at the last board meeting, so I did meet with the panel with Dr. Mancuso, and we do have a little bit of concern regarding the language that talks about nursing homes, since Dr. Mancuso has that type of work has really dwindled down in his area. So he's looking to expand to make sure that he is able to practice in multidisciplinary settings as the current contract calls for. The other issue that we are proposing to the board today, that we did talk to the panel about a little bit, was the option for him to work in a non-multidisciplinary setting with a monitor provision, similar to the provision that was in his 2015 order that required a monitor if he went into private practice. Now, Dr. Mancuso can answer your questions, obviously, but it is not his intent to go into private practice. But he was interested in telehealth positions, those kind of positions where it may not be labeled as a multidisciplinary setting. So we would request if the board would consider giving him that option if he went in that kind of route as far as his employment opportunities. I would just quickly point out that Dr. Mancuso, the 2018 contract that he's currently under was based on an incident from 2011. Now, he did have the complaints from 2014 as well. We would just request consideration that Dr. Mancuso has not been in any kind of, there hasn't been any incident in his practice since 2015. There was the 2018 contract, but again, we would point out that that was based on a 2011 incident. So we would just ask again for consideration of that timeline to provide him an opportunity that really to broaden his scope as far as employment opportunities, since his nursing home positions have kind of dried up in the area of Stephenville where he is. Dr. Mancuso, do you have anything to add?
I do not.
Okay. Thank you.
Thank you very much. While they're here, does the board have any questions for Mr. Mancuso or his attorney? All right, hearing none. Thank you very much, Mr. Mancuso and Mr. Montes. Thank you so much. All right, Dr. Lambden.
I did have a question regarding why the structure, as far as, since we're considering expanding the possibility of service delivery to telehealth, I just wondered, what was the intent of the initial restriction specifically that I guess telehealth would ensure continue to ensure protection of. And I'm not sure if that's not worded, if that's worded not as clear as I intended, but do you understand what I'm asking?
I understand. Mr. Hyde raised his hand. Maybe he wants to answer that.
Well, I was going to try to, but I don't want to step on your toes.
No, go for it. If you miss
Okay.
anything, I might have something to add, but
Yeah. I think the original intent was what was discussed in the previous contract, and again, this was back in the end of 2018, I believe, was Dr. Mancuso was working in a nursing home, and so that's why there was and Dr. Mancuso loved the work in a nursing home. Seemed like Dr. Mancuso had a passion for it, and was stated at the time Dr. Mancuso had no intention of leaving the nursing home, and so that's why the licensing contract is written that way, where it says nursing home or other multidisciplinary teams, because what was felt is as Mr. Montes mentioned, there had been other complaints that had come in, but a lot of those complaints were old, and those were ones that were previously filed when he was in private practice. Ever since he had gone to a multidisciplinary team, not a peep. No, we hadn't heard anything. So that's why we thought, hey, this is working. Let's keep the good thing going and not have any issues going forward. And so that's I think just generally why that it was done that way, or why. Does that? I'm hoping that answers your question. I think that's what you're asking. But what was the intent, or why they were doing it? Why they had written it that particular way?
Yes, and so I wondered, since I didn't read anything contained in the new contract, would it be advisable to also add a stipulation that while telehealth, it would now be an option, that the multidisciplinary team sort of stipulation would continue to, because essentially what you're doing is we would be allowing private practice, again, solo practitioner.
Yeah, I don't think that the current contract as written without any edits would prohibit Dr. Mancuso from conducting telepsychology but it would need to be done through a multidisciplinary team. So I don't think that there's a current prohibition against him doing it. It's just a matter of, is it actually going to be a multidisciplinary team? That's
right.
the real question. So
We don't view telehealth or telepractice as being a different thing from in person. It's just a different method of delivering psych services. It's not a different type of practice. So I don't think there's anything in that contract that prevents the, telehealth or telepractice. But
Okay.
once you do away with the restriction of the multidisciplinary team requirement, that naturally puts you back in the area of private practice because you're now outside that team environment. And that is what we had all kind of agreed upon back in 2018 with this original contract, is we felt like, okay, all your problems arose while you were in independent private practice. Now that you're in this this group setting, this multidisciplinary team setting, like Patrick said, we had 0 problems out of Dr. Mancuso, not one.
Yes.
And so that works.
And I'm going to come to you, Mr. Adler, just a second, just to add something on that, Mr. Spinks, what he said, that I've said it, I think Patrick said it. We've pretty universally been of the opinion that that this agreement does not preclude telepsychology. And it doesn't even, when it cites nursing homes, it gives it as an example. It doesn't confine it to nursing homes. We've been clear on that in private, and from Mr. Spink's comments here on the record, it comports with everything that we've previously said. So, Mr. Adler.
Yeah, so speaking from my own experience, I think finding a telehealth, telehealth option within a treatment team setting is certainly doable. I mean, at least in Houston, I mean, he could conceivably work for a practice that just does like staffing meetings like virtually. Would that suffice too? Does he have to meet with his treatment team in person? Or with, like, because a lot of places do like staff meetings or consultation groups, virtually as well, which could be for him anywhere in the state. Is there any concern with that?
I don't disagree. Mr. Hyde?
I wasn't sure if that was a question for me or so. The only
It's
thing
always a question for you.
I don't think there would be a problem with if he was meeting with a multidisciplinary team virtually. I don't see that as a problem or a violation of the potential licensing contract. I was also, Mr. Chair, just going to mention Mr. Montez had raised his hand. I don't know if you want to call him or not.
I didn't.
Let you know he had raised his hand.
No, I'm happy to let Mr. to see what you have to say. Mr. Montez?
Oh yeah, and that was just based earlier on the comments regarding the proposal that we're asking for. And one more comment about that is, at what point can Dr. Mancuso kind of come out from any restrictions? And the way we've proposed it is if he's
We lost you, Mr. Montes.
He was
Sorry
on mute.
about that. I'm back. Can you hear me?
We can hear you.
Yes.
Okay. And maybe let me just talk about the provision of the nursing home. I know you said it on the record. It's not something that precludes him from doing telehealth, even as long as it's multidisciplinary. We just thought that the language that we proposed at the top, not considering the monitoring, would kind of just ensure that there was no doubt that he was able to do multidisciplinary outside of the nursing home setting. But again, we obviously respect what you all think about that. But the other comment, I'm not sure if you heard me on this or not, but was at what point can he come out from under these restrictions? At what point can he prove to you all that he's able to expand his work and put these complaints behind him? So the monitoring provision, again, in there mimics the 2015 order. He would still have to come to the board if you all allowed him to do that. He would have to be monitored. After a year, he could come back and say, hey, look, I did this. It wasn't multidisciplinary. I was monitored. Can there be another modification of the contract? But that's all I wanted to say about that as far as what we are asking for. It can be the top part and not the monitoring. We would just ask for modification, and especially for the nursing home language to be taken out if at all possible. Thanks.
Understood. Thank you. Dr. Landon?
Just my personal opinion, I think that it is incumbent upon Dr. Mancuso to demonstrate that he no longer needs any sort of supervision. And the practice monitoring is an opportunity to transition from the restrictions that are in place to some sort of monitoring to complete independent practice, if that is something that can be, that is feasible in the future and can be demonstrated that there's a reduced risk to falling into the same pattern of behavior as has been demonstrated in the past. I think that would give assurance to the board, as best as can be obtained, that Dr. Mancuso does have the ability to move forward and practice independently. I think in specifically reading the contract and the proposals and the draft changes that have been submitted on page 2, if you all have that document in front of you, the second paragraph, the only concern I would have really is if no practice monitor can be obtained, or no new practice monitor after one has been obtained and for whatever reason cannot continue. It says shall get approval from the board or its designee for a new monitor within 30 days. And it says if no new monitor is approved within 30 days, the licensee shall not practice in this setting until a new monitor has been approved. So just skipping over the next line, after 1 year of monitoring, licensee may request to be released from the monitoring requirements upon the recommendation of the practice monitor, which must be submitted to the board. Now, my only concern with that, or something I think maybe we may consider, is what if after 1 year, the only practice monitor was the one that was initially secured and then for whatever reason discontinued? Do we want to consider putting in there a minimum number of meetings with the practice monitor, regardless of whether it is 1 year of monitoring or not?
Dr. Becker, I think also, Mr. Montes, thank you for being here. I'm going to let the board discuss this now. I think it's important. I'm going to come to you, Dr. Becker, now. We've heard from the licensee and his attorney. I think it's important that Dr. Becker and I can at least explain what we've seen and what maybe our thoughts are. Dr. Becker, go ahead.
I think it's really important to consider that this is not the first contract and that this is not one issue. And Dr. Mancuso entered into this contract and willingly, and the contract that was signed in, what was this, 2018 or 2019?
18.
2018 did not include a monitor. It was an open contract that he agreed upon to practice in a multidisciplinary supervised setting where he would constantly be in a team environment, and that was done for public protection so that he would not be practicing independently and he would have other people around him in his practice, and knowingly signed that and knew that. And the revision of this says that it has to come here and cannot go back to SOA. And that was signed, and he knew that that was what he signed. And so and it very clearly states, I'm not going into private practice. I'm not going back to private practice. And so I am struck by this baby stepping towards independence and private practice, knowing that this was very clearly signed into with the intention of, I am good with this is where I need to be, and this is where I am. So that is the piece that I understand that the world has changed, and I understand what was brought with the request was to not impede the ability to make a living. But I also hear that, you know, there are other options that are not monitoring and seeking private practice and independence that I think are not to the spirit of the original contract, which make me a little bit uncomfortable.
I want to just add, I was on the board then and I was involved in this ISC, and I've been involved in plenty of ISCs where we have agreements that have, most agreements have some sort of expiration date, or after a certain time, this rolls off. That's not on here, and that's not by accident. So I'm not going to go into the facts of everything from back then. But I can tell you, this is, I was not the board chair at this time. This was done very deliberately and very conscientiously, with a lot of thought put into it. And I'm with the risk, this was written in such a way to protect the public. And the reality is that it has worked. We had multiple issues with Dr. Mancuso leading up to this contract. And since this contract has been put in place as it sits, we've had no problems. And so I believe it's working, and I believe that's not an accident. So, Mr. Adler, you had your hand up, I believe.
Yeah, a couple questions. So what you're saying, Dr. Becker, is that the implication, or not the implication, was the intention for when he signed that was for perpetuity, that he would not pursue private practice into the entire future of the rest of his practicing of the field of psychology, right? And
That's
that
what
was
he
done
said, is that he has no interest in private practice.
okay.
That's what his lawyer
So
said, that he has no interest in private practice.
okay. And that was done, as you say, John, for at the time, done not by accident, not so that's fine. That's what I I think also I remember he came to our last board meeting, and with the impetus was for this request was for severe financial strain, right? And not being able to a longer, he can abide by those and still make a living. I'm sensitive to that. And
Agreed.
I want to do everything we can for this individual within reason. And if we need to keep a provision that, reinforces the private practice, but maintains he can do, teletherapy with, even in a virtual, meeting with other team members in practice, that's fine. I just want to make sure I'm a proponent of giving him a little bit of leeway here, based on when I think he spoke to the board directly last time. So, but that doesn't mean, I think the private practice rule was there for a reason, and I'm not, saying we should change any of that. So I do want to give this guy some kind of leeway.
I'll have something to respond to you on it, Mr. Adler. Mr. Spinks, go ahead.
Excuse me. Just one other option I wanted to throw out there for y'all. You've always got the option, if you're worried about the transition from multidisciplinary or the team-based practice setting into this is independent practice just with a practice monitor. If you're worried about that, you've always got the option. You could say, look, you're going to have to undergo an evaluation, kind of a fitness for duty type evaluation, to see whether or not there are any concerns. We could select the individual. We can make him pay for it. You've got that kind of an option. I'm not suggesting that. I'm just making sure that everybody understands all the options that are available, to the tools that are available to you. So We've done that in the past on some stuff for people coming off of like practice monitoring or probated suspension. We've used that kind of a tool and said, well, you're going to have to go get evaluated, and they're going to, and then whatever limitations they say in that report are going to be imposed upon your practice there. You're going to have to follow those limitations. So that's an option for you too. And there's all kinds of permutations of that you could do. So just keep that in mind.
I'm just going to say this is that given the aggravating nature of multiple infractions that led up to this, given the nature of the complaints that precipitated this, and given the fact that this agreement, as it's been proposed, the way I see it, does not actually address any of the underlying issues that got us here in the first place. It does not mitigate any of those things in preventing to give me any assurance that if I'm going to put my name on saying, yeah, come on, we're going to loosen this up, that we're not going to see a complaint or something happen in the future. So I am disinclined based on this request. I think this asks far too much without actually addressing any of the underlying issues that got us here in the first place. And so I'll let Dr. Becker make her recommendation, but as somebody who I've been on this issue from the beginning to now, and having been involved in the discussions, I am recommending no change to the existing agreement. I don't usually vote. If it comes to a vote, that I will be voting no on modifying it.
I would vote no on modifying it to this. I am torn on whether there is a compromise in the middle. I am not unempathetic to Dr. Mancuso's situation. And I told him when we talked earlier in the month that I am not trying to restrict his practice and make it impossible for him to make a living. I want to see him be successful. And I don't know what the middle is.
Dr. Landon?
I'm just curious, and I completely understand and I agree with everybody, who has stated that, we definitely want to be sensitive to an individual's ability to earn their living. I think that's fundamental. However, I'm wondering what exactly precipitated now this request to modify the contract. And I don't know if anybody knows
that. Go ahead, Patrick.
I think what was discussed is that since COVID, a lot of the work in the nursing homes, the nature of those have changed immensely. And so a lot of the work is essentially dried up. They've gone with, larger companies, and the smaller company that he was working for has, I think, gone out of business. And so he had a few existing contracts, and I think pretty much they've all dried up. So it's they've just gone with different larger companies, larger providers, and that's why the ask is because the current conditions where Dr. Mancuso was working don't exist anymore, I guess.
Yes, and I remember that was an indication at our last meeting where this came up. That was the case. So I guess if I'm more specific, I'm wondering from the last time this was brought to our attention to now, what has changed for Dr. Mancuso?
I think that what we understood was his ability to make a living in the nursing home has been diminished.
Right, but I thought it had been clarified now in this meeting formally and before in private conversation with him or his attorney that this does not limit him exclusively to nursing homes.
Exactly. And that's partly why I'm disinclined. This is asking for essentially for us to take the, shackles off to go into independent practice.
And I
And
think, sorry to
no,
interrupt you.
no,
Do
go
you-
ahead.
I mean, do you guys want to hear from Dr. Mancuso what John and I heard from him? I mean, you can ask Dr. Mancuso to explain it to you all, because I thought this is what John and I heard several days ago, and we, a couple of weeks ago, and we asked him, and we explained that the nursing home in the original order was used as an example, and that there are a multitude of other ways to seek employment that are not within nursing homes, and virtual employment would be fine as defined within this order, as long as it didn't fit the definition of an independent practice and it were still in that multidisciplinary definition, by which the order of this contract was written. And this was what we asked them to present a language at this meeting by which to adapt the order based on what they were looking for. And this is what we received.
And what it feels to me like is that I'm being told that don't want to go into independent practice, but yet the agreement that we got essentially allows independent practice.
Yes, and so to your point, John, I think I think you nailed it when you said basically we really haven't seen anything that addresses the violations that were not one. I think maybe not two, possibly three. I don't have the background that all of you have, but as I'm remembering, there were several violations of the same kind for this particular individual. And you have two options. You have the constraints of a contract that limit the practice in a very narrowly defined way, which is what we have previous to this, what is in place now. Or we really don't have anything to address and give the board assurance that the root of the issue within Dr. Mancuso that led to those violations has been addressed. So the way we obtain assurance for the protection of the public is in continuing a restricted, narrow way of, with a lot of, structure and a lot of supervision, access to a multidisciplinary team, or a combination of those two, or we look at some of the issues characterologically, if you will, that have led to those violations in the past that got us to where we are at this point.
So should we request, more of a letter like from Dr. Mancuso addressing those points? Would that be something that would be the next step? Would that be wanting to do that?
Mr. Adler,
yeah.
I don't mean to cut you off. With respect, we met with them. We asked for more. We took time. We had a meeting. We had staff drive up from Austin for it.
Okay.
We did better than a letter, and I understand. I didn't hear any of that. We gave them that opportunity.
If I may,
please.
I just wanted to follow up on what Dr. Becker said a few minutes ago, and I completely agree with both Dr. Becker and Mr. Blameless. I don't want to impede anybody's ability to earn a living. My problem with this is that our job as a board is to protect the public, and at the point that a public member and a practicing member have met with the individual in question and seem to have come to the same determination, that is that's a red flag for me on approving anything like this. And the idea of continuing to protect the public, I'm a big fan of keeping guardrails on as much as we can. So I just wanted to throw out there my agreement with some of the comments that have already been made. I liked what Dr. Becker said about maybe coming back with different language. I don't know what the answer is. I'm not opposed to hearing a different suggestion. But as presented today, I don't believe this is it.
Mr. Adler, thank you, Mr. Bridges.
Yeah, I was wondering if we could go into executive session and kind of, because there's some things in the meeting that maybe we're not able to talk about right now. So I can get a better idea of, I mean, this is my feeling, you know, to kind of go over like what Dr. Mancuso said or didn't say, what he was not explaining well, because, you know, I was not at that meeting and maybe I'm not privy to all the details that you guys are. And in lieu of anything else, you know, executive session might be helpful to just kind of talk about more of the details. Just
Mr.
a
Hyde,
thought.
can you answer that for us?
Yeah, we're not permitted to go into executive session to discuss or deliberate specific details. If you have a specific legal question, we can go into executive session and I can address that specific legal question. But what it sounds like is if you're wanting to discuss specific details about his particular case, any sort of deliberations or discussions about the decision or any decisions need to be made in the public meeting. So I don't know if we'll be able to do what you're asking for in an executive session, if that makes sense.
What can we characterize about, I mean, because I've been guarded in terms of disclosing the details publicly in a public forum, in a public meeting, from stuff that was discussed in an ISC and complaints that were made. What can we speak to in the public of the nature of the violations that were found that precipitated this agreement?
Okay, remember the reason we had this exact same discussion at the last meeting, and the whole reason we did the ISC is because there were questions about the facts of the underlying complaints that kind of gave rise to that licensing contract. We can't talk about those complaints or the facts in those complaints in an open meeting. That's why we had the ISC, so that the members of that panel could, and then they would be able to formulate a recommendation or opinion and then bring that back to the full board. Now, what the full board can do here and now is talk about Dr. Mancuso as he sits here now. You know, the nature of the request, whether how those requests operate or address the concerns that the ISC panel is bringing back to you. I know it's a little, you're operating off of gathered information from the ISC panel, but we did that for a reason. If I want everybody to remember, and it's important for the public to understand what we're doing here, why we did it this strange way, because you can't go into executive session to talk about this stuff. Statutorily, you're not authorized to do it. So that's why we had to do it in this kind of odd manner. ISC had complete reign. They could ask anything and everything they wanted to. They could look at all the old complaint information to kind of get a better understanding for how Dr. Mancuso got to the point where he was. Having done that, you've now heard from the ISC panel, Dr. Becker and Mr. Blemowitz. It's now up to you to decide, is the requested change well, is it something that you want to do based upon the concerns and the opinions and recommendations that Dr. Becker and Mr. Blemowitz have brought back? Now, having said that, you guys are free to call Dr. Mancuso up here and ask him pretty much anything you want to. Just don't ask him about what the underlying facts were in those old complaints, but you can ask him about Dr. Lambden. You can ask him all that stuff you just mentioned a minute ago. You know, what has changed between when you came before us the first time and now? Why is it you're asking for practice monitor? Why, you know, that stuff is all free game. He's got to talk to you about that. Unfortunately, I wished it wasn't this way, but unfortunately it has to be in an open meeting. I don't like the fact that it is, but that's what the law is. So we're not allowed the privacy in this setting, unfortunately, but there's no way around that. And I wish that weren't the case, but it is. Does that answer your question, Chair Blemowitz?
Yes, it does. I think for what it's worth, having been familiar with the case and being involved in understanding what got us to this point, again, I said this, I'll be voting, if it comes up, I'll be voting no. I am unwilling to put my name on changing this. That I feel that strongly about it. And I went into this with an open mind to try to see if, you know, if my feelings could be changed on it. And what I've not heard, and I see it, what I don't see in this agreement is an acknowledgement of where and how the infractions happened in the past, and how do we mitigate for those. I don't see that. I didn't hear that. I was hoping to hear that, but I never heard that. And as such, I'm just unwilling to modify this.
Mr. Blanowitz, are you accepting proposals right now? Or,
yes,
motion?
Dr. Lambden just raised her hand. I want to make sure we get done with discussion before we hear that. Go ahead, Dr. Lambden.
Yes, I was just going to echo Mr. Bridges and what he had stated in the past. For me, I really don't think I necessarily need to hear from Dr. Mancuso. I think that, you know, you and Dr. Becker were in the IFC meeting, and I think that, you know, I'm okay with going forward should we choose to vote on this. And I think I'm good with moving forward on a vote.
Mr. Bridges?
Yeah, based on the recommendation of the ISC members and in light of the facts presented, I move that we deny the adjustments to this as submitted.
Is there a second? It's been seconded by Dr. Singh. Is there further discussion? All those in favor of denying this requested change, signify by saying aye.
Aye.
Aye. Opposed?
I abstain. I'm abstaining from this.
Okay. Opposed, say no. And show Mr. Adler abstaining. All right, everybody, thank you very much. It's not an easy conversation, but I appreciate everybody's insights and attention to that. Do we have any recommendations for agenda items for the next board meeting? Hearing none, you guys know that you can email me or Ms. Moore anytime on that. Have I missed anything? Ms. Moore, have I missed anything else?
No, everything's
right.
covered.
Then I'm going to go ahead and move to adjourn without any objection. Sorry, Dr. Cartwright.
Yeah, just something that came up in BHAC. There was just I know that we had discussed there's that kind of there's the bill, the House Bill 4062. There was some talk about maybe making that a topic for insights over lunch. If I know we had just talked about it, and that it's kind of carries over to all four of the boards under BHEC, and it's kind of a hot topic and just something to maybe think about as a discussion going for insights over lunch.
Sorry, I know bills by topic, usually not by number. What was the topic of that bill?
It's the one with audio and video.
Yep. Yep.
Child custody evaluations.
Yep.
That it's required now, and so it's kind of a hot topic, and it's on a lot of people's minds right now. So just something to think about. I don't know if that's like an immediate, but just something to think about for a potential discussion or insights over lunch down the road.
I would agree. Any other requests? All right, hearing none, going to adjourn without objection. This meeting is adjourned. Thank you very much. Time being 11:34 a.m. Have a great day, everybody.
Thank you.
Have a wonderful day. Bye-bye.
Oh.